I had one cautionary point, and you may have seen this coming because it's where you cite me in the paper and call me an elitist. And of course, I'm wearing a blue collar today, so you can't call me that. I want to caution you about the distinction, and you acknowledge that it's stylized, where you sort of say the elitists versus the populists, and the elitists are equated with sort of common law versus the populists who are interested in abstract principle. That might work in the context of the debates in the 1790s over the Alien and Sedition Act to some degree, although to call Madison, for example, a populist who owned hundreds of slaves and was president of the United States is, again, it's a little stretched, I think. But I also think that you need to, if you look outside the context of this debate, for example, Madison himself, when earlier on talking about how to interpret the Constitution, said when you see common law terms, you need to interpret them according to their common law meaning. For example, in many of the debates over rights during the American Revolution, the complaints were over the denial of common law rights, not abstract rights. Similarly, George Mason, in his objection to the Constitution, complained that the U.S. government wasn't going to be bound by the common law. So the common law, I don't think there's this dichotomy where the common law was thought of as the province of the elites and sort of abstract rights were the province of the people in any generalizable way, although it may have appeared that way in the context of this one debate. So I would be careful about that. And also, more generally, the move towards abstraction can sometimes be a move. I think of the caveman lawyer, right? That sort of, I don't understand your fancy laws, right? But I do know that blah, 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 right? And so when Madison makes that move in the context of this debate, for example, right? He knows perfectly well what the common law means. In other contexts, he appeals to the common law. But here he's like, well, that's not working for me, so I'm going to do something else. So I think, again, I would be careful about accepting that sort of structure of argument.
Stephen?
So I think I can buy everything you say about the regulability of natural rights by governments and still think the paper doesn't quite go so far as to say that this government can't, is able to regulate speech. So you very briefly around, it's not numbered, but around your footnote 318, talk about the Congress shall make no law part of the First Amendment and kind of quickly move past it, but I'm not sure. I felt like that was too quick, in part because, we think the Establishment Clause says the federal government can't establish a religion, yet we think of religions as something that governments can establish. So maybe that governments can regulate speech, but not this government. Governments can establish religion, but not this government. And in some way that might track the complete language seems to potentially track the Federalists' view that we couldn't regulate speech there was no power to regulate speech anyway, so we don't even need a First Amendment, right? And maybe I'm just repeating some of the things that you kind of cite to, but it just felt like it moved very quickly, and it just seems entirely possible that we were just violating the First Amendment from the beginning, right? The fact that soon after there were laws that seemed problematic, it might have just been that we just started off violating it.
Great paper, thorough, careful, insightful. I want to go to Campbell v. Galley. They say, I want to raise the question of how it's possible to do the work and then whether you need to do the work, whether you can spare yourself the swamp, right, of having to persuade your audience that we can distinguish over the relevant domain between the free speech principles themselves and the particular applications, right? So a lot of people make this distinction in the law, right? I mean, you follow Whittington, and a lot of smart people do this. I frequently find that I can't understand it because I frequently think, like a common lawyer, I don't actually know the content of the principle until I've seen it applied a bunch of times. Then I know the content of the principle. So I suppose you could have a case where two people generate sets of applications that are non-identical, but they're sufficiently convergent, right? 8 out of 10 times we apply the same way. It might be meaningful to say that we're working from the same principle. Or it might turn out after you do the next 10 iterations that it's still only 8. Right, and now you've discovered that actually maybe you're working with different things at the level of principle. all of this is to say that I'm not sure that one can easily make the move to say, even though the applications are different, it's the same principle. And then I think, I don't know that you need to take that on to make this paper work. It reads a little bit to me like it's a thing that you take on at a moment in the paper where you want to show the path from your historical work to legal outcomes. And elsewhere in the paper, you're quite clear in ways that make a lot of sense to me to say, the historical work I'm doing does not directly generate legal outcomes. And I think if you stick to that posture, you can spare yourself this problem.
I appreciate that. So, John, I take this point to heart. I mean, I do think there's not a strong distinction. You could see people moving back and forth between modalities, but even with respect to the common law, there is a vibrant discourse at the founding that the common law should not be determined by resort to precedent. And so, for instance, in Massachusetts, they banned the recording of judicial decisions. Now, it turns out to be not a good move because then the judges just cite the Massachusetts judicial decisions because they haven't recorded the New Hampshire ones. But it is a view among many people. I'm not going to label whether it's the more prevalent view and exactly what sort of socio-demographic group it requires, but there is a view that the common law should be determined in a sort of common sense, practical reasoning way, rather than by resort to the artificial reason of the common law, as Cook would put it. And I just want to suggest, I have not done the work, but I just want to suggest that if we limit ourselves with respect to your work or with respect to what Laura was writing about in the Fourth Amendment context, to the sorts of sources that make assumptions about what the common law is, that it's a Cook-based view, we're going to miss a slice of founding era discourse. And so this paper, I think, teases out that there is an alternative way of thinking about the nature of constitutional law and even about the nature of common law at the founding. Christina, I think I'll have to take another look. So one issue is textual. I think the text, I just completely agree with the Federalists. To say that you can't go past a threshold doesn't say you can't go up to the threshold. It's just not what the text says. And so the Federalists actually use this affirmatively to say Congress shall make no law abridging the freedom of speech, to say, well, they can make a law abridging speech so long as it doesn't abridge the freedom of speech. And I think that's a perfectly reasonable move. The second thing I'll say is if we just think about text in context, the entire context of the bill over the passage of the Bill of Rights is to have parity between state and federal rights. So there is not a move amongst the proponents for a Bill of Rights or against those who are opposing a Bill of Rights to have federal rights that do something different with respect to the federal government than states' rights do with respect to the state governments. And Richard, I'm going to have to think more about this. I really appreciate the comment.
Tiny footnote
Yes.
to agree with what you said about Cook and all of that. It was really not until Langdell in the U.S. that it was accepted that cases were law as opposed to mere evidence of law, and the law being these principles. The idea that the primary items of law were cases was a Langdellian departure, and a controversial one.
Used to sell case books. That's right. So the next three are Charles Barzun, Chris Green, and Evan Bernick.
Well, mine sort of builds off of Richard. So if you want to sort of punt on that one, you can punt on this one too. It's kind of methodological question, and it goes to just the point he raised, which is it seems like at points you are quite clear to try to distinguish the historical and the legal claims. But I'm looking at page 211 of the big packet, right? I think it's in your intro or the preliminaries part. Where you said, viewed historically, the First Amendment did not enshrine a particular rationale for expressive freedom, and then you talk about what it did or did not incorporate certain rationales. And that's very much sounds like the language of legal language, legal conclusions about the meaning of the First Amendment. And I guess I find it
implausible or hard to understand what it would mean for it to not incorporate any rationale at all and to just be a kind of process. I mean, they did use the words, and as you just said, they were trying to reflect the state constitution, so there was something that they thought it was doing, and there was some value that they thought that was achieving, no matter how vague or contested or whatever. And then the other sort of part of that is, and because I think it might be related, is a few pages later on, you talk about how you describe your project as one that is internal to the system. And I just wonder what you mean by that. It seems like you're using it to suggest that as a kind of defense against the claim that you're not saying that everyone thought this way, and I guess I don't think that's necessary. I don't think anyone would accuse you of making that claim. And to the extent that you're trying to show that it's a coherent system of thought, you can just show that and you do show that by your argument. So I think it's unnecessary, and my recommendation would be to cut the whole paragraph, which is too bad because you cite me. But it could be improved by deletion, I think.
Yeah, Chris?
Okay, I guess I'm encouraging you to set your sights on the 14th Amendment, too, which uses the word abridge, and I've annoyed a number of people here making these aggressive arguments about the word abridge, and some of the evidence in this seems to undermine some of my claims. So I have this argument that you can't really abridge natural rights because natural rights are often moral Platonic reality and they can't get shortened. But you quote these people saying abridge natural rights. If we understand that to be shorten the exercise of them, I mean, it's the exercise that exists in contingent reality. That's the kind of thing that can be abridged. So I'm not given up on that cluster of arguments quite yet, but I just wonder if I'm hearing natural rights wrong and thinking of them in terms of moral reality, because a lot of what you say sounds like, well, no, it's the contingent exercise of them. And on that score, I wonder if this when you say regulation in the public interest, or when your sources say regulation in the public interest, how much of an equality requirement was in there? Because if abridge means act contrary to the general public interest and not give special rights to certain people, that really helps me in terms of making an equality reading of the general privileges of citizens of the United States. So, you see these arguments that you're criminalizing criticism of Adams but not Jefferson. That was the problem. How much of that is in public?
Evan?
So I'm struggling with the concept of the public interest and specifically how that relates to the judicial role in enforcing the speech clause. You conclude that a natural rights reading of the speech clause doesn't forbid the government from regulating speech, but it does require the government to regulate speech for reasons that serve the public interest. Of course, that presumes that there are some interests that aren't public interested in which the government can't rely upon or pursue. But you also find during the founding era that decisions about the public interest are left to the people and their representatives, not to judges, thus, in your words, making natural rights more of a constitutional lodestar than a source of judicially enforceable law. So if the government burdens speech without a public interested end in sight, it's acting unconstitutionally, but judges can't do anything about it. I want to press you on whether you think that that particular conception of the judicial role is constitutionally commanded, or whether one might, consistent with the Constitution, adopt, well, some of the doctrines that the court has in fact adopted in its speech jurisprudence, like the rule of strict scrutiny for content-based speech distinction, which rests upon the premise that if the government is distinguishing between different kinds of speech on the basis of its contents, well, it's usually up to no good. So I was hoping you would address that.
Great. Okay.
So Charles, and I guess getting back to Richard, so what I'm thinking is if we just read the First Amendment as saying not that Congress shall pass no law abridging the freedom of speech, but we said Congress shall pass no law that limits speech against the public interest, or that limits speech without taking due consideration of the public interest. At that point, it seems to me the meaning of that phrase is distinct from the ways that we might then cash out that meaning in particular cases, given our conception of the public good. And it's useful, I think, for us to understand that distinction, that we may have different views of what the public interest requires. And and that our disagreement may operate on that level, rather than operating on some sort of lower level of we're just out there looking for the law, sort of like a common lawyer would in a common law case. And we're not resorting to high-level principles in that case. And so that's what I'm going after. I think I want to defend that exists. What I'm not sure of is whether I need to try to defend that it exists in the way that I'm doing it. And I don't want to get myself into a minefield, and that's why I didn't answer your question, because I just need to think through. But I mean, at least conceptually, I think there's something there, and I at least want to defend that thing is there. That we can have an idea of, do something good is a command, and then we have different ideas of what that tells us. That doesn't mean we're doing something different when we follow the command. We may just have different conceptions of the good. And so that's what I'm getting at. In terms of the internal versus, point taken. I'll have to go back and look at this. I mean, all I'm trying to say is that I'm trying to explicate a system of thought. I'm not trying to explicate how everyone actually thought about the freedom of speech. And so it's a very elitist enterprise. I'm looking to these elite sources that tell us something fairly authoritative at the time, Locke, Blackstone, and so forth, and trying to figure out, were we to resort to these elite sources, as we know that certain founding era elites did, how would we think about this? Sort of, what is the best fit for the materials at hand? And so that's what the enterprise is. I'll have to think more. I added that paragraph after anybody has critiqued it. So I mean, after I've presented this anywhere. So I'll have to think more about that. Chris, in terms of, a bridge, I mean, a bridge could mean a positive law recognized right. So, I mean, there's certainly things that Congress could abridge that are positive law rights that have been recognized either at the time of the founding or potentially that have become recognized fundamental positive law protections of expressive freedom that we didn't have at the founding. So there is something there to be abridged. In terms of the general public interest requirement, yes, it's an equality norm. It's a requirement of equal consideration of everyone's interests. So it doesn't mean everybody has to be, the outputs may be different. You may be able to tell the guy who wants to go around saying blasphemous statements that he's not allowed to say blasphemous statements anymore. So in that sense, the law treats him differently, but at least at the initial stage, you are considering his interests in equipoise with everyone else's interests. So it is a equality norm. Evan, I want to disclaim that the First Amendment itself tells us anything about judicial review. So I don't think that a theory of judicial review is baked into the meaning of the First Amendment. I think when we think about how the founders discussed the First Amendment, we have to be attentive to their ideas about judicial review. This is all bound up in discussions about practical legal problems. And so I certainly want to be attentive to that, but I do think that the problem of judicial review is a separate problem. And so if you see the judicial power as being capable of evolution in a way that recognizes a greater role for judges post-Caroline products, by all means. I mean, I think my theory of the First Amendment in that way might be consistent with some parts of modern law that might surprise some people. And so I do want to say that at least at the level of what the First Amendment means, there are certain ways of justifying modern law, or at least parts of modern law, as sort of prophylactic rules under a more aggressive theory of judicial review that might actually fit what we're doing. I'm not out to defend that. I'm just suggesting that that's a possibility.
All right, next three are John McKyle, Shakira Sanders, and Michael McConnell.
So, Judd, at the risk of sounding like a broken record or a one-trick pony, I want to encourage you to talk about the necessary and proper clause. So this comes up for me in a couple places. One is your discussion briefly of Wilson's State House Yard speech. The second is your discussion of Madison's speech, June 8th speech introducing the Bill of Rights. But what I want to focus on is at the very end of your paper where you cite the minority report. I mean, this goes to this kind of question about the threshold interpretation of the First Amendment. And you cite the minority report in Virginia and Patterson's circuit opinion. So I think another way to look at this whole topic is not just on the rights question, but on the power to pass the Sedition Act in the first place question. And if you look at the minority report, for example, which Kurt Lash, I think, has persuasively argued was authored by John Marshall, but even if you don't think it was Marshall, it quite clearly articulates a view that rests on the necessary and proper clause, in particular this government powers provision that I was talking about with respect to Ilya's paper. So the idea is that one of the powers vested in the government of the United States is the power of self-preservation or something of that sort, and then there's a kind of a series of implications that lead all the way to whatever might disrupt, in the national interest, basically, or as you talked about. And my recollection, having looked at this once, is that not only Patterson does this, but all of the Supreme Court justices on circuit who hear these cases are making similar kinds of arguments. At least that's my recollection. I looked at this once. I think Iredell does. I think Ellsworth does. And then also the northern states, several of the northern states respond to the Kentucky and Virginia resolutions with resolutions of their own, and several of them explicitly quote the necessary and proper clause, in particular this idea of unenumerated powers like self-preservation vested in the government. So I think if you bring this out, it'll just kind of thicken your story. It's not just a question about not infringing the right. It's the idea that the Federalists, they really did have a conception of implied national power, wherein acts like the Sedition Act were just fine. They just simply, it didn't really turn on the enumeration question the way Madison and Jefferson were arguing, but rather on this question of implied government power via the necessary and proper clause.
Shapiro?
I just have a comment, which is that I had the opportunity to read this paper, and at that time I was not aware of who the author was, and it was an earlier draft of the paper, and I just want to thank you, or maybe not thank you, but just say great job on the sort of restructuring, the revisions. It certainly, in many ways, made the paper more approachable for me. Of course, I also assumed that the paper you would be presenting was the old version, so I was excited that I had notes, and then saw the first page and realized that
Sorry.
I had to read it again, but it was a nice reread.
Good. Thank you.
Michael?
Paper. I think I might disagree with a couple of points that I think are minor, but maybe they loom larger in your mind. So I want to sort of give just quickly an alternative view and see what you think. So the First Amendment says Congress shall not abridge the freedom of a speech or of the press. I agree. I think I agree with Chris about the importance of that, but it means that there is this pre-existing right. But as I see it, there's a difference between the freedom of speech and the freedom of the press. That is, the freedom of speech is a natural right, whereas I think the freedom of the press was both a natural right and also a common law right. But I can't find any evidence of an actual sort of common law right of freedom of speech. And so it seems to me that as to press, we both have whatever natural right there is, but in addition to that, we have the common law rule, right, which is the no licensing rule or the no prior restraint rule. And then if we believe Madison's majority report, maybe in this side of the Atlantic we add a little bit more to that. That's not my problem, but at least we have these common law protections against licensing and prior restraints. But for speech, all we have is the natural right. And here I guess Evan and I are both worried about the same thing, which is this idea that it's limited by the, quote, by the public interest, as opposed to being limited by the natural rights of others. And I don't see how the public interest seems too broad to me, and I don't see how it works either for natural rights or for the constitutionalized version that we have after the First Amendment comes along. The public interest, it seems to me, can't be baked into the natural right because there's no society yet. I can see how the natural liberty of the natural right of others reflected in the natural law means I don't have the right to hurt other people, but there is no public interest. I don't get it. And then once it's constitutionalized, it's a standard that is completely left to the legislature. And so seems to me it doesn't work for purposes of the First Amendment. So why isn't it the case that what the First Amendment means with respect to speech is Congress can't abridge the freedom of speech, which is the natural right to speak limited only by the law of nature, which is you can't use that freedom to hurt other people.
Okay.
All right, that's great. So, John, I agree for the most part that a sort of broader discussion of Federalist constitutionalism might help here. So I'm definitely going to go back and look at that. I want to reinforce your point by saying that the theory, the social contract theory that is undergirding the discussions of natural rights is also undergirding debates about the scope of federal power. And so Hamilton Wilson, going back to 1786 debates about the bank, this is the bank under the Confederation Congress, thinks that there is a national body politic, and therefore, because there is a national body politic, there are inherent powers that attach to sovereignty. And so that is clearly the Hamiltonian position too. It's clearly the Federalist position, and the Jeffersonian response is this. So try to remember the language of the Kentucky Resolution. This compact, parentheses, styled as a constitution, out of parentheses. Jefferson denies that we have a federal body politic. And that is the core debate. So that's not the debate I'm getting into in my paper, but that is the core debate of constitutionalism leading up to the Civil War. It's the debate that McCulloch intervenes in by saying it's a constitution we're expounding. There is a national body politic. That's essential for McCulloch is an intervention in the ongoing deliberations about the constitutionality of internal improvements. There is a view of sovereignty embedded in the notion that we have a national body politic. So I fully agree with that. I would just say, all of that said, we could still have a Sedition Act that abridges the freedom of speech, right? They could just say you're not allowed to criticize the government. That would abridge the freedom of speech. Which gets to Michael's point, which is there are common law protections for the freedom of speech, namely that it can only be a restriction of harmful speech. So there is protection. It's protection recognized in the view that you have a truth defense, for instance. It's recognized in the jury right, which attaches not only in press cases, but in speech cases, getting back to Fred's point that this is a common law right largely rooted in procedure, not rooted in a limitation on the authority of government in a sort of substantive sense. But there are common law protections here. And the Federalists agree that there are common law protections that go beyond the press right. So not a single Federalist in the entire debate over the Sedition Act takes the view that the First Amendment is limited to a rule against prior restraint. It's a historical error.
That isn't what I'm suggesting.
Right, but everybody has a view that there is a broader protection here. The broader protection includes protection for the freedom of thought, for the freedom of opinion. It doesn't include the protection to try to mislead people. And so when you have a malicious intention, you're prosecuted for the malicious intention, not for the statement. But there is a broader protection here. And so if you're looking for something that's constitutionalized, that's judicially enforceable, I think that's what you're looking for. Maybe you would say then that the residual kind of natural right general public interest principle isn't actually part of the First Amendment, fine, it's part of the Ninth Amendment, it's there either way. But that part isn't then constitutionalized in sort of a modern sense and made into a special prioritized right that ends up having some special status. And that's why when we have a debate about whether or not the government should be abridging, say, theater performances, it's not debated by discussing is a theater performance speech or not, because there's no priority for speech. It's just a natural right, like the right to liberty. And so there's no special protection that's afforded to speech as speech in this sense. Rather, there's a recognition that there is a common law right to well-intentioned statements of one's views, freedom of opinion, as it's often called, that I think supplements the right against prior restraints.
All right, the next three, Larry Solom, Randy Barnett, and Steve Smith.
Super cool paper. So just a structural suggestion, and then I'd like to return to Michael's question. So the structural suggestion is that the paper sort of reaches its thesis on page 60 of 67, and then there's sort of 7 pretty quick pages working out the implications of the thesis. So the thesis is stated in the second full paragraph, right? You have a caveat and then you state your thesis. The First Amendment recognized the ordinary natural right of expressive freedom, along with presumptive or perhaps absolute protection for a set of customary rules with more determinate legal meaning. And I just think that the paper would be a much stronger paper if you more fully worked out the implications of that view. And honestly, although I have said that the freedom of speech might create this large construction zone, always sort of just hypothetically, right? I was really kind of surprised at how much you say is left up in the air at the very end of the article on page 67. And I did not think the arguments between 60 and 67 warranted the final paragraph of the article. So I just think there needs to be more here, or you can split it off if you want to, because it's long already. But these 7 pages, I think, could be significantly expanded, and the article then would be much more powerful. So in response to Michael's question about public interest, right, the paper, in refuting sort of the libertarian view, right, so that goes that comes immediately after the passage I just read, and then you refer back to footnote 141. But the evidence in footnote 141, I do not think establishes the public interest theory, right? So first of all, we should be very worried about the idea that there was a public interest theory in the 18th century, right? Because that's just anachronistic language. The language that the parentheticals at least, right? And obviously parentheticals are just parentheticals, but the parentheticals in footnote 141 just don't establish that. Some of them actually are talking about the infringement of liberties of others and would lend support to the view that you say 141 refutes. And then, there are these other specific examples of things that, were considered to be allowable restrictions of natural rights, including blasphemy laws. But then the specific is that we need blasphemy laws because otherwise the oath will lose its value and the legal system will not be able to function. And this is not saying anything in the public interest is okay. This is a very specific kind of argument. And others, I think, other restrictions fall in sort of the public morals category. There was a theory of the police power. One of the conventional formulations talks about the protection of rights of others, the promotion of public health, and the public morals. So I just wonder whether that part of the part of the paper that's back at 141 might benefit from considering alternative interpretations of what regulations were allowable to sort of a general public interest interpretation. And I believe that, Randy might be saying something along these lines too, but I think that that would provide a fuller answer to the point that Michael just raised.
Randy?
Yeah, that really leads up to what I was going to point out. I like the paper better than I like your explanation of the paper here at the conference. I thought it was pretty careful in sorting out a number of different concepts which are distinguishable. For example, the difference between natural rights and positive rights, in the sense that these are rights created by the compact. They're not natural, they're not pre-existing. That was good. Then that the natural rights are regulated by common law, or they're defined as a positive law matter by common law, which I think is also historically warranted, although obviously the status of the common law was disputed. But then here, and I guess it must also be in the paper, but I didn't see it as much there, you really adamantly seem to equate positive rights with positive law. And you, which are not the same thing. A positive right is a created right. A positive right is positive law, but then the other question is it's not the only positive law, unless it is. I mean, there are other kind of laws. I mean, common law itself is positive law. It's positive law in positivist sense of law. So there seems to be kind of a quick move from positive rights to positive law. Then you go from positive law to constitutionalized law. I don't see much in the sources that would justify that move. Do they talk about constitutionalized law? I don't remember that being there. Maybe it was there. There was a lot there, so I can't remember it all. You would remember it better than I would. But that's a move that, and I agree with you that this constitutionalization of rights is a modern concept, not to be read back. But now let's go back to what was there. Natural law rights. What was the statute of natural rights? It's now, in the paper was pretty careful. Here it sounds like natural rights just don't really have any legal effect. It's not law, as you were saying earlier in your presentation, but that doesn't follow. Just because they're not protected qua rights, which I agree, doesn't mean they're not protected. Natural rights could be protected by federalism. Natural rights could be protected by separation of powers. Natural rights could be protected by a doctrine of equitable construction. I know somebody who argues that. Why would you even have a doctrine of equitable construction except for the fact that natural rights deserve and merit protection? Call it positive law protection. That would be, now that would be I might go farther and say natural rights are also protected by a doctrine that says the only appropriate regulation of liberty, and all liberty may be regulated reasonably, but the only appropriate reasonable regulation of liberty is that which is not arbitrary or irrational, which is actually on the power side rather than on the right side. It's the existence of the rights that give rise to the need that laws not be irrational or arbitrary. Then there's a secondary question of whether that's justiciable, whether that judges can decide those questions. But conceptually, an irrational law or an arbitrary law is not an appropriate regulation of liberty in the public interest, which I agree is sort of an anachronistic way of saying it. So for all these reasons, I think that your gloss on your paper goes farther than your paper, unless I missed it. I usually am looking for it in your papers too, but I might have missed it here. And I think you go too far. I think where you're going, or your spin now, exceeds what you've shown. But what you've shown is super cool. And so I might be content with that and not the extra spin.
Steve?
Well, I wanted to raise a concern. It seems like maybe should be raised in an originalism conference about the implications of the paper. So I think there's a sort of a little dialectic back and forth that sometimes happens in the first few minutes of a class on freedom of speech. I'm pretty sure it happened in the free speech class I took from Robert Bork, and back when I used to teach constitutional law, I try to have it happen in the first few minutes of when I get to freedom of speech, and it kind of goes like this. The first point, you start with something like Hugo Black's position, it's kind of absolutist. No law means no law. The text just, and that's just the plain meaning of the text. It sounds like kind of a public meaning sort of thing, and it just means you can't restrict speech or something. So then the counterpoint comes right and says, well, yeah, that is the plain meaning of the text. The counterpoint says, and that's absurd. Of course, that's completely untenable reading. A bunch of counterexamples are given, perjury and threatening the president, and et cetera, and so that's completely untenable, and it's evident in Black's own position where he claimed to be taking this position and then come up with silly things like, well, here it's speech brigaded with action, or one thing or another. It just shows how how untenable it is to try to stick with the plain meaning, the public meaning, sort of. But now the rejoinder, the next point comes in and says, but we need to look at the text more closely and maybe in its historical context. It doesn't say Congress shall make no law abridging speech. It says Congress shall make no law abridging the freedom of speech. And that phrase might have been a term of art. And then if we looked into the term of art, we might get something more sensible and usable, and we could still stick with it, something like the original meaning and so forth. So then we investigate that. And one investigation might be sort of along, say, Leonard Levy lines or something, and it might be disappointing. I say, yeah, maybe it was a term of art and it meant no prior restraints or something, really limited and not nearly as much as we would like. But maybe that's what we're stuck with if we stick with original meaning. All along, of course, there's a lot of incentive here to get off the originals thing and say, we just can't do. We got to come up with some other way of giving meaning to it because this originals thing doesn't work. And Levy you might say, well, that's what we're stuck with. Your paper, though, seemed to me to be investigating that question, or you could read it as investigating that question, and basically saying, no, it was not a term of art. Everything was completely contested. All the practical application. There was a sort of discernible structure of thought, a really loose one, that there's a kind of a natural right, but it can be overcome in terms of the public interest. But you just can't read this as a term of art, that had some understood content. And that's what the First Amendment was referring to. And I wonder whether that leaves us in the end, again, back with, this originalist approach. It hasn't been used that much with free speech, unlike other areas like Establishment Clause. It just hasn't done much work. And there are good reasons for that, because it really just can't give us anything very valuable here.
Okay.
That's great. Thanks. So, Larry, in terms of the structure, and I think this point ends up feeding into my answer to your other question, the essence of the paper, and this bleeds into Steve's point as well, is to say we can't go back looking for the freedom of speech as a term of art until we understand the language of founding era rights. And that requires a lot of heavy lifting at the front. And so the structure of the paper is to try to lay out the heavy lifting in the front and only get to the First Amendment after we have understood sort of the language of founding era natural rights. And so that's why I've done it the way I've done it. And the point on implications is very well taken. I would rather publish this paper and have you all supply the implications and supplemental essays than try to do that work myself. I want to tease out some implications. I want the piece to place. But that's not where my heart is. I don't want this to be an originalist potshot piece, and I think there are opportunities for originalists to take this history and expose some level of continuity that non-originalists have denied. I think non-originalists could also take this piece and expose the substantial degree of difficulty in turning the founding era history, apropos of what Steve's saying, into workable modern law. And so I'm still unresolved on that question. I've tried to tee up some possibilities in the conclusion, and I'm not sure what to do past that. In terms of specific limitations on speech at the founding and whether or not they go beyond a concern for the public interest, I want to say two things. So one is that I'm relying in large part on the general framework of social contract theory and natural rights. There is a clear indication in all of the available sources that natural rights are regulable in the public interest, and so I do want to rely on that. The second thing I'll say is that although the founders at this higher level of abstraction have that in view, they also have a very, very healthy, sometimes bordering on libertarian, respect for the freedom of speech. And so the actual restrictions that they impose on speech, although going well beyond what we would do today, are actually not freewheeling, allowing tons of stuff to be regulated all the time, as the government says. They actually do have a fairly healthy regard for some aspects of the freedom of speech. And I'll just say that, the points in footnote 41, they go beyond these sort of immediate injury points that I was identifying with Michael. So we could see them as second order points to help prevent immediate injury by bolstering the political society itself. And in fact, that's all I'm saying, is that, so the founders, the natural rights founders, are Wilsonians. They think that ultimately the source of governmental authority rests on the legitimacy of the protection of natural liberty. And so, sure, you, at a second order level, you have to justify governmental authority as an effort to obtain that end. But it isn't limited to direct infringements on the natural rights of others. That's not where the scope of governmental authority stops. Randy, I'll just say I'm very discomforted that I'm not sure I disagree with anything that you said. I don't, that gives me pause, but so I'm not trying to go beyond the paper and the remarks. I am, in the remarks, accepting a convention of talking about the legal enforcement of natural rights that's very different than the very nuanced discussion that you were introducing. And so I agree, they are legally enforceable in a very nuanced way, equitable interpretation, potentially a rule against arbitrary restrictions and so forth. They're just not legally enforceable as natural rights in the way that we might, yes, exactly.
Don't let him off the hook so easily. That is, it's at least contested whether the common law prior to Bentham and Austin's carping about it was understood as positive law as opposed to merely discovering non-positive pre-existing natural rights.
I've been higher authority has told me that we have ceded the last 3 minutes to the shuttle. So let us thank Judd and Fred. And again, thanks to the organizers and to all of you for coming here.